Hello and welcome everyone. Again, we are here with another three power-packed topics of legal current affairs. और आज के तीनों टॉपिक हैं रिसेंटली वी गॉट अ न्यूज़ दैट सुप्रीम कोर्ट के अंदर अब 38 जजेस होंगे, राइट? एंड we'll be discussing that. Also, we'll be discussing Transgender's Personal Amendment Act 2026, and we will be discussing the HSA murderer that cannot inherit. So inherit अगर जैसे हिंदू secession act के अंदर usually there was no provision like that. Now they have added that murderer cannot inherit anymore, right? Let us see what all things are going to be covered under Supreme Court judges. 34 से 38 कैसे हुआ? What was the issue and why did they came up with this provision, right? So अगर मैं बात करूं Supreme Court की, so this happened on 6th of May 2026. The Union Cabinet ने एक proposal को approve किया. The proposal was that Supreme Court judges जो sanction strength थी 34, and now they will be 38, right? There is a bill that has been presented in Parliament as well with respect to Supreme Court, a number of judges amendment bill 2026. Now it has been approved by cabinet. Parliament bill has been given to the Parliament also, and Parliament will pass it, and then of course President will sign it, and then strength will automatically go to 38, right? Abhi tak we had 34 judges. This is the first time that Supreme Court has sorry, this is not the first time the Supreme Court is actually increasing the strength with respect to the judges. It happened way back in 1950, where Supreme Court established with 8 judges with respect to CGI plus 7 judges, right? In 1956 to 1986, there was progressively raised. We raised judges from 11, then 14, and then 18, and then 26, right? In 2009, we had strength fixed to 31 judges. In 2019, we increased the judges to 34 judges, that is 33 plus CGI. May 2026, we had the cabinet approved the bill with respect to raise to 38 judges. This all has come into picture with respect to Supreme Court judges, which is a new thing that we have seen, right? Moving on, we see Hindu Succession Act, Section 25 Hindu Succession Act, that murderer cannot inherit. It came into picture with Manjula and others versus D.S. Srinivas, which is a 2026 INSC 465 as report. We had 2 judges, Justice J.B. Pariwala and Justice R. Mahadevan, and this judgment came into picture in May 8 to 9 in 2026. Basically, the section of 2025 states a person who commits murder or abates the commission of murder shall be disqualified from inheriting the property of the person murdered or any other property in furtherance of the succession to which he or she committed or abated the commission of the murder. The facts were simple that D.S. Srinivas claimed ownership of properties through a will because K. Raghunathan, who died on May 4, 2019, right? Srinivas was the prime accused in Raghunath's murder. Criminal trial was going on, and Bangalore Civil Court rejected the plaint under Order 7, Rule 11 CPC. Karnataka High Court reversed it, and Supreme Court restored the trial court's order. The Supreme Court outcome was that Srinivas should be barred from asserting inheritance rights under Section 25 of HSA, and both on statutory grounds and principles of justice, equity, and good conscience came into picture. Then this is the key highlights which you should know of the same. There is testamentary succession covered. No conviction is required. Murder includes culpable homicide, devolution via Section 27 HSA. Testamentary succession covered means Section 25 will bar both interstate and testamentary succession. Suppose somebody has written a will already, it is known as interstate, and testamentary if somebody has tested on the will, right? A murderer cannot escape by claiming through a will. No conviction required. Formal criminal conviction is not a condition precedent. Civil courts will apply preponderance of probability standard. Then murder will include culpable homicide as well. Broader, strict Section 300 IPC definition. Also, abettors equally disqualified, not limited to direct perpetrators. Devolution via Section 27 Hindu Succession Act will include the property that devolves as if the disqualified person has predeceased the deceased, passes to next eligible heir. Then we have Transgender Amendment Act, which came into picture recently in 2026. There was a stay that was supposed to be asked because, of course, there was a lot of protest going on. Also, with respect to the Transgender Amendment Act, we had seen a major change, and that major change we have discussed already. So SC has recently refused the stay that was supposed to be there on May 5th, right? There was this a bench known of CJ Surikant and Justice Joy Malia Bagchi, right, that issued a notice to center and all states and union territories and refused interim stay on the Transgenders Act. The case was Lakshmi Narayan Tripathi and Original versus Union of India. Matter referred to a 3-judge bench, right? And Surikant stated, issue notice, the matter shall be initially placed before 3-judge bench to the constitutor of the CGI, constituted by the CGI. No question of grant of any interim order, no question of interim stay, right? There should be President shall assent. President Draupadi Murmu gave the assent on March 30, 2026. It was passed by Parliament in Lok Sabha on March 24th and on Rajya Sabha in March 25th. Enforcement status assented but not yet formally notified. The 2026 amendment changes and challenges. Key changes in 2026 were that self-ID removed. Anyone who claims that this is a certain identity that I hold of, that is, removed. A medical board is required now. Earlier, there was no need of such a medical board, but now they have introduced the medical board as well. There would be mandatory reporting. Hospital must report gender-affirming surgeries to authorities. Criminal penalties, new penal provisions, medical groups warn these any criminalization, consensual care. Then we can see narrow definition of removes trans man, trans woman, genderqueer includes, and those subject to mutilation, right? So there is petitioner constitutional grounds that can be stated in NALSA in 2014, where we saw legislature cannot nullify a Supreme Court judgment without addressing its legal basis. Also in Article 14, 15, 19, 21. Equality, non-discrimination, expression of identity, right to life with dignity. And then we see in Puttaswamy, which was mandatory hospital reporting, violates right to privacy. Hormonal therapy came into picture by Senior Advocate Kaju. Persons receiving hormonal therapy had treatment stopped abruptly. All these things can be seen with respect to the following judgment. That is it from my end. I really hope you like the session. The PPT would be available on your Telegram channel. So go and get it from there. Bye-bye. Take care.